I don't want to be a fearmonger, but I do believe that they're trying to go on a path that will totally dismantle Roe v. Wade, and we have to be vigilant.
Speaker Pelosi issuing that warning as Alabama is adopting the strictest anti-abortion law in the country, sparking protests and court battles, which the law's supporters say they want, betting that Trump's additions to the judiciary could change all of this. And then consider this action in the Senate today. 52 senators voting to confirm Trump pick Wendy Vitter as a federal judge. Now, she has falsely claimed Planned Parenthood kills 150,000 women a year and that abortions cause cancer. She also joins over 24 Trump picks who refuse to say whether the Brown versus Board decision banning segregation was correct.
Do you believe that Brown versus Board of Education was correctly decided?
I think I get into a difficult area when I start commenting on Supreme Court decisions, which are correctly decided and which I may disagree with.
Now, it can be difficult for judicial nominees to discuss certain new issues that they might have to later rule on, or every specific case under the sun. But civil rights leaders stress the unanimous Brown decision against apartheid is not a difficult case to say you support, and tomorrow marks the 65th anniversary of that ruling. So we turn now to one of the nation's leading civil rights advocates, NAACP Legal Defense Fund President SHERRILYN IFILL. Thanks for joining me tonight.
Thanks for having me, Ari.
What do you see as important here, as we mentioned, given the anniversary tomorrow and the refusal to discuss this case in so many of those Trump nominees' hearings?
Ari, it's actually quite significant, and I think it's important for us to kind of see the wake-up call. There are nearly 30 judicial nominees who, since Wendy Vitter, have refused to say that Brown versus Board of Education was correctly decided. This is a sea change from what we have seen over the past decades. Those on the right and those on the left, Chief Justice Roberts at his confirmation hearing talked extensively about Brown and saw no problem talking about it. He thought it was as likely to come back before the Supreme Court as Marbury versus Madison, that seminal case that created judicial review. Justice Alito said that Brown versus Board of Education actually vindicated the true meaning of the Equal Protection Clause of the 14th Amendment. Even Justice Kavanaugh last year described Brown versus Board of Education as the most important case in Supreme Court history. And yet suddenly, in a move that I have to believe is orchestrated, these Trump nominees have refused to discuss the Brown case. And we would be foolish to ignore this and to think that this is an accident or by chance. It is not. And because Brown constitutes such an important and seminal moment and expression about American democracy, we should all take note.
Well, and you say that you believe it might be orchestrated. Rod Rosenstein's the most famous Deputy Attorney General, I think, in American history. He's got a replacement who's less famous, but as you know, is now on the job. And this is what he said when pressed about it by Senator Blumenthal.
Was Brown versus Board of Education correctly decided?
Senator, I don't think that it would be a productive exercise for me to go through the most thousands of Supreme Court opinions and say which ones are right and which ones are wrong. Whatever the law is, whether it's the decision I would favor or disfavor, I see it as the role of the Department of Justice to uphold the law such as it is, unless Congress or the courts change it.
What do you say to their rebuttal, as you just heard, that they're just not going to get into it?
Well, get into what? Get into whether or not African Americans are entitled to be treated as full citizens, whether the 14th Amendment truly guarantees equal protection to all people in the United States. Brown is not one of thousands of cases. It is as seminal a Supreme Court case as Marbury versus Madison. It is a case that speaks directly into modern American democracy. And until last year, this was not controversial. The idea that somehow you have to demur on Brown because you're going to be on a slippery slope is absolutely absurd. If Chief Justice Roberts recognized Brown as lying at the center of the canon of the rule of law, if our entire profession has been united over decades on the right and the left about the importance of equal protection and the Brown decision, it's astonishing that someone who's going to be the Deputy Attorney General overseeing departments like the Civil Rights Division that has a portfolio of cases that directly depend on Brown, to feel as though he can't talk about the Brown case is truly astonishing. That he was confirmed today is quite alarming. We should beware. Tomorrow is the 65th anniversary of Brown versus Board of Education. I can tell you that the Legal Defense Fund and other civil rights groups who are out at our rally this morning on the Hill, we are not going to be deterred. We see what is at stake.
Right.
We see what the plan is, and we're leaning in hard to protect equal rights for all in this country.
And as we talk about civil rights under the law, you think about all of the cases for leniency, for commutation, for a second chance, given the racial disparities in the system. And so while I have you, I'm curious your reaction to how the president is using his pardon and commutation power. Here, for viewers who may have forgotten, is Conrad Black, a very wealthy individual who went to prison, wrote this book, Donald J. Trump, a president like no other, and has now received this commutation, from the president. Your reaction?
My reaction is that it's appalling, but it could never be more appalling than the pardon that was given to Sheriff Joe Arpaio, someone who was convicted of engaging in racial discrimination, racial profiling against immigrants, who was held in contempt by a federal court. And who was pardoned by this president. The president is using his pardon power strategically to speak to his base. He pardoned Scooter Libby. That spoke to a particular segment of conservative Republicans who wanted to see the vice president's former counsel, Vice President Cheney's former counsel, vindicated. He's using it very strategically for his own power, not to recognize a true injustice that has been done. There are many thousands of people waiting for mercy and clemency from the President of the United States. These do not strike me as the best candidates, but more importantly, it shows you that when this president talks about law and order, he does not mean law and order. He means the law that he believes in. He means the order that he wants. He means law and order only as it applies to people that he demonizes and stigmatizes as being criminal. And so this pardon is very much consistent with that. But frankly, the low watermark was Sheriff Joe Arpaio. I don't know if it gets any lower than that. And so this president's use of this pardon doesn't surprise me.
SHERRILYN IFILL, thank you so much for being here tonight.
Thank you, Ari.